All right, we're on tape 21, and today we're going to be talking about the right of privacy. Now, you hear that word? What does it mean? You look closely at the Constitution, there's no mention of the word privacy. And so, therefore, if it's not mentioned in the Constitution, is there an actual right to privacy? Well, it's an interesting question. I'm going to use a couple of Supreme Court cases. First of all, what does it mean? What does privacy mean? And there's been a big fight about that over time. One of the justices in 1928, one of the justices on the Supreme Court, Justice Louis Brandeis, said that privacy is a right to be left alone. Okay, so if you look at the Fourth Amendment to the Constitution, it says that you're secure in your persons, places, and papers. Okay, that implies, at least to the justice, and I think to most of us, that you have a right to be left alone. Government can't come snooping in your stuff. Okay, so we have a right to be left alone. But where is that found in the Constitution? So I'm going to show you two Supreme Court cases. One was 1965, and it was Griswold versus Connecticut. And Griswold was with, I need to put it there so you can see it. Griswold was with Planned Parenthood. And at the time, early 1960s, it was illegal to use birth control. Griswold wanted to use it. She went to Planned Parenthood, and they decided to actually set up a test case before that would go to the Supreme Court to challenge the law that prohibited birth control. So basically, what happened is she got a prescription for birth control from a Planned Parenthood doctor. They called the cops and told them what they were doing. The cops came and arrested them. The whole idea was to get it to test the validity of the law, the constitutionality of the law. And the law, she was convicted, the law was challenged all the way up to Supreme Court. And the Supreme Court in 1965, in this case, Griswold versus Connecticut, said that in fact there is a constitutional right to privacy. There is this right to be left alone when it comes to decisions about reproduction for married couples. Griswold was married. Okay, it was extended a couple years later to include unmarried couples. And then the big case, and we've talked about this before, 1973, Roe versus Wade. Okay, and remember, Roe wanted an abortion. Her attorney was a McMurray grad, Sarah Weddington, and she was 25 when she took the case before the Supreme Court. It took a couple years. The court came down in this ruling in 1973 that said there is a right to privacy found in the Constitution, and that right extends to reproductive decisions, including abortion. Now, where is that right to privacy found in the Constitution? Well, that right to privacy is found in the Constitution in the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment. It's found in various places the court held, but not necessarily in one place. Okay, so Roe versus Wade then said reproductive decisions are private and the government cannot interfere, at least at the beginning of the pregnancy. They said the government can interfere later on in the pregnancy as the baby inside becomes viable. Okay, so viable means living outside the womb. Okay, so Roe versus Wade establishes a right to privacy in various amendments of the Constitution. That's since been extended in cases about homosexuality to include sex with other people. So, not just reproductive decisions, but also decisions about intercourse. And basically, the Supreme Court held in a couple of different cases, including the fact that marriage between two people of the same sex is constitutional. Supreme Court said that we're just going to stay out of marriage and reproduction in most cases. Now, can a state prohibit marriage between someone who is old and someone who is a minor? Yes, of course they can. Can the state prohibit marriage between someone, a man and two women, or three women and a man, or however you want to do that? Polygamy, for example. Yes, they can. But in terms of the basic one couple, male, female, male, male, female, female, that is a marriage decision, a sex decision that is protected under the Constitution. Okay? In other words, what the court's saying is there is a right to privacy when it comes to these intimate things. Okay? Since then, there's been other efforts to expand it. Okay? Is there right to die? Is that found in the Constitution? Supreme Court said it's not in the U.S. Constitution. It might be in state constitutions, but it's not in the U.S. Constitution. I think there's 8 states that currently allow some form of physician-assisted suicide. But most states, certainly Texas is one of them, that does not allow it. And people have tried to find it in the U.S. Constitution. Supreme Court has been unwilling to say it's there. Basically said it's not there. Um, Other things of privacy. Well, we've already talked about DNA. You know, in the end, question of DNA and ownership of your DNA is a question about your privacy, your body. Do you have that right to own what is yours? Think about the debate about the coronavirus and how do we, as a society, monitor people who have not had it yet, or monitor people who have had it. There's this idea Google and Apple are talking about fixing our phones. And when they fix our phones, there's an app that they can use that would simply alert us if anybody around has had the disease or hasn't had the disease, any way you want to configure it, okay? Isn't that a great breach of our privacy? Okay, some other countries are doing exactly that. China, for example, New Zealand, they're doing that. They're monitoring people on the basis of their COVID-19 status. Here in the United States, it raises huge privacy issues, and I'm not sure where we want to go with that. Okay, so we'll stop right there. Is there a right to privacy? Right now, under the Constitution, there is a right to privacy. It covers marriage, it covers sex, it covers reproduction. Beyond that, we accept that there is privacy, but how far it goes and the specifics of it, we're still struggling with.